Good morning. Welcome back, everyone. Now we are going to be taking a look at the Human Services Board. We have a bill from Representative McFawn, who it's a short form bill, but we first are going to need to take a look at what does it say in statute about the Human Services Board. So Katie is here. Welcome, Katie. Welcome back. We're going to talk about something besides H91.
It's 92.
So welcome.
Thank you. Good morning, Katie McFawn, Office of Legislative Counsel. So in the interest of full disclosure, I have never amended these sections on the Human Services Board. This was really my first close look at them. So I found them a little dense. There's really two sections that get into process. So I broke them into slides and tried to summarize, thinking that would be helpful. If we get into it and you rather look at the actual statute, we can flip back.
I think this is going to be perfect, Katie.
Okay, great.
Yes, and it'd be great to post them up there on the screen too.
Okay. Here we go. Okay. So while there are at least 25 places in statute or particular sections of statute where the Human Services Board is referenced in one way or another, there are really two main statutes that that sort of describe what the board is, and then a second section that describes what the board does. So I have a deeper dive, obviously, into those. So first, the board is created within the Agency of Human Services, and the statute specifies as a successor to and continuation of the Social Welfare Board. So potentially, if you ever chose to amend that, that might be a reference that you might not need anymore. It consists of 7 members appointed by the governor with the Senate's consent, and they are appointed to 6 years terms, and the appointments shall be tiered in a manner that prevents more than 3 terms expiring in the same biennium.
No more than 3? More than,
It's on the slide.
Oh,
is it no more than 3 terms?
no more. Yeah.
Yeah,
Thank you.
okay.
Thank you. The governor appoints the chair. And the statute says the board's duty is to act as a fair hearing board on appeals brought pursuant to the next section. We're going to look at section 3091. Same section where we're looking at the board. Meetings are held at times and places warned by the chair or upon request of 2 board members or the governor. 4 members of the board constitute a quorum, except 3 may be a quorum upon written authorization of the chair. With the approval of the governor, the board may appoint 1 or more hearing officers who are outside of classified service, and the board may also employ secretarial assistants as it deems necessary. And then there's an annual report of the board, and you might remember this when we go through that list of all the reports due to the committee, that you get a report every year from the Human Services Board. So it goes to various policy committees, the appropriation committees, about the fair hearings conducted by the board during the preceding 3 years, including the total number of fair hearings, the number of hearings per year involving appeals of decisions to AHS and each department within AHS, with appeals and decisions relating to health insurance through the Vermont Health Benefit Exchange reported distinctly from other programs. The number of hearings per year based on appeals of decisions on eligibility, benefits, coverage, financial assistance, child support, and other appeals categories. The number of hearings per year based on appeals of decisions regarding each state program that the board has jurisdiction over, and the number of decisions per year made in favor of the appellant, and the number of decisions per year made in favor of the department or agency. So that is it for what the board is, and then we transfer to the next section, what the board does. So an applicant for or recipient of assistance, benefits, or social services from DCF, SEVA, Dale, DMH, or from the Health Department's WIC program, or receiving somebody who's a licensee or an applicant for a licensee from one of those departments, except from the Health Department, may file a request for a hearing from the board. And a fair hearing will be granted to any individual requesting a hearing due to the individual's claim for assistance, benefits, or services being denied or not acted upon with reasonable promptness, or an individual who's aggrieved by any other AHS action that affects the individual's receipt of assistance, benefits, services, or a license or license renewal, or an individual aggrieved by AHS policy as it affects the individual's situation. So those are the instances in which the board will grant a hearing. In terms of the hearings, it specifies that the hearing shall be conducted by the board or a hearing officer. And we saw that they could hire one or more hearing officers. The chair may compel by subpoena the attendance and testimony of witnesses and production of books and records. The witnesses are examined under oath, and it requires the board to adopt rules with reference to appeals. The rules must provide for reasonable notice to parties and an opportunity to be heard and represented by counsel. Subsection C requires the board or a hearing officer to issue written findings of fact. If the hearing was conducted by the hearing officer, then the hearing officer's findings have to be reported to the board, and the board has to approve or adopt the findings of the board unless there is good cause shown for disproving them. And then the board shall enter an order based on the findings. After the fair hearing, the board may affirm, modify, or reverse a decision of the agency, determine whether an alleged delay was justified, and it may make orders consistent with this title requiring AHS to provide appropriate relief, including retroactive or prospective benefits. The board is to consider and to have authority to reverse or modify decisions of the agency based on rules that the board believes conflicts with state or federal law. And the board cannot or shall not reverse or modify agency decisions that are in compliance with applicable law, even if the board disagrees with the results affected by those decisions.
Katie, when you're referencing applicable law, is that including rules?
Potentially, yeah. I think if the board is looking to see if applicable law has been followed and the statute doesn't specifically speak to something, but rule does, they would apply that, yes. Hearings, subsection E. This subsection requires the board to give written notice of decisions to AHS and the person who is applying for the hearing. Unless a continuation is requested or consented to by the person who requested the hearing, an order shall be issued by the board within 75 days after the request for the hearing. It doesn't matter when the hearing was, but 75 days after the request. And that applies to orders concerning TANF and Medicaid. Notwithstanding the provisions of subsections C, D, and E1. So from here on out, we start to get a little bit more complicated. But C was our language about the hearing officer doing the findings and the findings being approved by the board. D was our section on the board decisions that the board can modify and reverse, but they can't modify If the outcome is applicable, the law has been applied, but they don't like the outcome after the law has been applied. That's a section we just looked at. And subdivision E1 is this section right here. So that's what we're notwithstanding.
It sounds like that, it sounds like it said the board must delegate its fact-finding and decision-making authority to a hearing officer. So, when does the board itself actually make decisions?
I don't think the board has to delegate to a hearing officer.
Okay,
I think the board could do the fact finding itself. It can hire one or more hearing officers and it can have the hearing officer do the fact finding, but then the board itself has to sort of ratify those findings, assume them as its own and approve them.
So then what does it mean here when it says the board must
Must, yeah,
delegate?
that's what I was
fact-finding
referring to.
and decision making?
So what I was saying was, for everything not withstood, that is the case. And then for what is, when we're talking about in subdivision 3, is just expedited Medicaid hearings. So for expedited Medicaid hearings, we have a special carve out. And in that case, the board has to delegate both fact finding and decision making. In other instances, the hearing officer isn't doing the decision making, it's just doing the fact finding. So it's doing both here with regard to expedited Medicaid fair hearings.
and so then in the expedited situation,
Mhm.
so I get the concept of expedited, you get one person, and so does that then fully constitute to be the decision of the hearing officer is then fully meant to be the decision of the board? Or would they, if they disagree with the hearing officer, do they then have an opportunity to actually have a full review by the board?
That I don't know.
Okay,
I'm not sure. I think that's a good question.
okay,
My guess would be that they would have the chance to approve any decision of the hearing officer, but I'm not completely sure
okay,
in this case. And then this language goes on to talk about in accordance with federal timelines. So I tried to find a cross-reference in the medical assistance chapter to the board. I'm assuming that federal Medicaid statutes have specific timelines in which appeals within the agency have to be heard, but I couldn't find specific language in our statute.
okay.
So I'd have to dig in a little bit deeper to understand that.
So, sorry, May to understand more. So what I understand this to be saying is that because there might be federal deadlines or timelines, this exists in order to make that happen in the timelines. In other words, hire someone to do this work for you because the board may take too long.
That's how I'm also reading it.
And so the earlier reference to it being permissive, if you will, whether or not they hire hearing officers really is the case. Because this sounds like it's
Well-
required in this instance to be handled by a hearing officer.
Where it's expedited.
Where it's expedited.
Do we know?
If it's not expedited, they still could be the board or hire someone.
Yeah, and we're going to hear so this is a short form bill, so we have to have a vote to take it down, a straw poll to take it off the board and work on it, or, to move it out of one category. So if we make that decision, then, we're gonna have the, hearing officer, we'll have board members, we'll have people from the, probably from each of the departments that are covered by this, as well as, people who have brought cases to the Human Services Board. Yeah, go ahead, Esme.
I was looking at the 2024 report of all the appeals and all that, and I noticed there's first of all, it's like a 45% increase in the past 2 years, so a ton of appeals for a variety of different reasons. But one other big number that stood out to me was the number of cases that were dropped before hearing, which was like kind of surprisingly high. And I was wondering at what stage in the rule process, like, does this the language was actually withdrawn before hearing.
Mhm.
So I'm like, so where in this step number and rules does that happen, or how or why?
The statute doesn't address being withdrawn. I would imagine that there might be an agreement reached with the department, or the department, once they realize it's been appealed, they might take a second look at it and decide that the person is eligible or that the benefit sought, something like that. I think that's probably a better question for
Sure.
the board when they come in, but that would be my guess.
I mean, I just know from experience and having been there that when it is appearing like there might be a decision in favor of an individual, that the department sometimes don't want human services precedent to be set on certain decisions. And so they make a decision on their own and then it's withdrawn.
Okay.
I mean, that's not all the cases, but I know
Yeah.
that that's at least one reason why that happens.
Mhm. Sure.
The agency or the appellant may appeal the board decision to the Vermont Supreme Court. So the last stop is not the Human Services Board. The decision of the board can be appealed to the Vermont Supreme Court.
And we had one of those that we were referencing earlier this year in H13, our Medicaid rate bill about decision that was made by the Human Services Board. The Supreme Court said, no, I don't think so, and sent it back to the Human Services Board, essentially resulting in the in favor of the person who was appealing. And you can find the report that Esme was just referring to under our reports and resources page, right from our homepage. And it's filed under not A, but H for Human Services Board, because it comes directly from them.
And then while the court's final determination is pending, the agency must follow the board's order, except as it relates to retroactive benefits.
What does that mean?
If you have been denied services for the past 5 years and the board is saying, like, yeah, you probably should have been receiving those services for the past 5 years, you maybe get the services on an
Going forward?
good basis.
Yeah.
That's how I would interpret it.
Well, in some situations, some of the rules say that you're able to continue services. So like if it's a change in services, thinking about our testimony yesterday in the developmental disability system where people are starting to see changes in their service plans and they're wanting to appeal those. I'm pretty sure that the Dale rules say that you're eligible to continue to receive those services pending that appeal. But I think that's different depending upon, what rule that they're under. Okay, thank you.
The board or a party to the board's order, or both, can petition the court for relief against disobedience or noncompliance with the order. So there's been a board order and somebody isn't following it. Either party or the board itself can petition to the court to have that order followed. And when the court does find there's been disobedience or noncompliance, the court shall hear and consider the petition and can order a writ of mandamus, which is ordering the government agency to do what it is supposed to do. A writ of prohibition, which is sort of like ordering a lower court to do it's sort of like a higher court overruling a lower court. So it might be, in this case, telling the board to do something differently. It could order an injunction to stop a particular action. So that those are instances of noncompliance with a board order. Okay. Notwithstanding subsections D or F. So D again is our list of board decisions, the board actions, the board can affirm, it can reverse, it has to follow the rule, even the state law, federal law, even if the applicable law doesn't provide an outcome that the board likes. So that's one thing we're notwithstanding. The other thing we're notwithstanding is the appeal of the board decision to the Supreme Court. So notwithstanding those two pieces, the secretary of AHS must review all board decisions and orders concerning TANF, the Office of Child Support, Medicaid, and the Vermont Health Benefit Exchange. So for decisions on those particular topics, there's like an extra layer of review. So there's a board decision, then there's the secretary reviewing the board decision before there's a chance of it going to the Vermont Supreme Court. The secretary must adopt a decision or order of the board, except that the secretary may reverse or modify if the board's findings of fact lack support in the record, or the decision or order misinterprets or misapplies a state or federal policy or rule. The secretary must issue a written decision addressing legal, factual, or policy basis for any reversal or modification of a board decision or order. I will just say, if the committee does end up looking at these statutes more carefully, there are a lot of places with inconsistencies. I'm sure you're sort of picking up on that, but just little things like sometimes we're talking about an agency action and sometimes we're talking about a department action. Sometimes we're talking about federal and state law. Sometimes we're talking about policies and rules. So just like a lot of those small details, there's lacks consistency throughout this, and probably it's an old statute that has been amended many times. So
Although not recently.
not recently. I mean, the last amendment was 2023. My guess is that was technical corrections. I think probably a lot of these have been small technical corrections over the years. Okay. Still notwithstanding DNF, board decisions and orders concerning TANF, Office of Child Support, Medicaid, and the Vermont Health Benefit Exchange are final and binding decisions of AHS upon approval of the secretary. The secretary must approve, modify, or reverse the board's decisions or orders if it's going to do so within 15 days of that decision. And if there's not action by the secretary within those 15 days, the board's decision is deemed approved by the secretary. Notwithstanding subsection F, that's allowing it to go to the Supreme Court. This allows only one claimant to appeal the secretary's decision to the court. Only the claimant to appeal the secretary's decision to the court.
Is there any provisions in the statute that enables, in this case, it's called a claimant or the person appealing, to be represented by someone else that they delegate?
Meaning that they have counsel?
No, I mean, like, I know that something like this, a person's guardian would be considered them in this case, but what about if a person due to disability or due to inability, they you know, designate someone to act on their behalf?
No, that's good. I don't know if the rule says anything, but the statute does not.
Okay.
The court can stay the secretary's decision upon the claimant showing of a fair ground for litigation on the merits. So the court can pause the secretary's decision if the court says it looks like there could be litigation on the merits of this, but not insofar as related to denial of retroactive benefits. So that is what we sort of talked about previously. Where the appeal pertains to Medicaid covered service decision made by DVA or an entity under contract with DVA to make those types of decisions, the right to a fair hearing shall be available to the aggrieved party only after the party has exhausted DVA's internal appeals process and has received notice that the adverse benefit determination was upheld. So I think this might be related to the expedited Medicaid, that there are certain situations in which there are federal requirements around what the appeals process has to look like before the Human Services Board statutes kick in.
Katie, this is the first time I've seen, you know, in your summary here, that we're an entity under contract with DVA.
Yeah.
So I'm just trying to figure out, so I know like designated agency decisions on Medicaid benefits are appealable to the Human Services Board. And is it because they have grants to do so that the service is kind of delegated that they do it? I'm just trying to figure out if there's no specific reference to that.
My honest guess is that it's not a legal reason. My guess is that this section, particularly because it's the last subsection in this section, was tagged on after the rest of the section was added. And so, the committee contemplating it was only thinking about this one provision and not how it relates to the whole.
Yeah. Yeah. I mean, just, there's obviously certain things that are decisions made by state government, but then there's also decisions made by entities that are not in state government that are still appealable,
Mhm.
and are still Medicaid services. Or in the case of DCF, might not be Medicaid services, but are still appealable because they're state funded. So it feels a little bit like, maybe that might be something that we might.
Yeah, it's not reflected anywhere
Yeah, it
else.
doesn't seem to be, yeah, okay.
Okay, so that's the end of the two sections, but I know you can't read this list, but this is. This is just to give you a sense that the Human Services Board is mentioned many times in the VSAs. So this is just to sort of give you a running list of every time it's mentioned, and we're only talking about 2 items, 2 lines on this list. So I wanted to give you some examples of other references to the Human Services Board in statute. Oftentimes it's just cross-reference. Sometimes a program will say, follow the procedures set forth in the Human Services Board. So that is a lot of what the references are. The board, there's language that the board is exempt from the contested case statute that is applicable to other types of contested cases, except with regard to one tiny subsection within that statute. So I've listed that and provided links if you want to see it.
What does that mean, the contested cases section?
There is a statute that talks about what type of notice has to be given in a contested case, what type of evidence must be available. And so this is creating an exemption for board proceedings with the exception of subsection H, which you're going to ask me what it is, and I can't remember off the top of my head. But that's an exemption. We have some instances that withstand certain provisions of the Human Services Board fair hearings provisions. For example, appeals from the divisions of voc rehab, division of voc rehab, blind and visually impaired. They have a carve out with regard to certain provisions. And then sometimes there's like an addition or sort of a heightened level of procedures in addition to what the Human Services Board provides. So I saw that with regard to complaints and appeals, then the Developmental Disabilities Act, reach up notice and appeal provisions had language, and also reporting around the abuse of children. And I would guess also vulnerable adults if I were to take a look at it. So that's just to give you a flavor of why the Human Services Board might be referenced in other sections.
It's an important, it's important for us to understand that, because if we do decide to take up the bill, we really have to be really careful about any potential changes that we might make because of the impact in a myriad of other places in statute and in state government operations. I mean, so, but I think there are probably things that we could do, one, to help it be more consistent and help it to, I think that there's a sense, at least by the member who introduced the bill, that individuals appearing before the Human Services Board don't have an adequate opportunity to present their case. And so, I think that there's things that we could do if we decide to take it up that can help in those cases that would, kind of help everybody, things that are sort of more global in nature. But we do have to be careful not to, interrupt what these things are, because we won't be looking at all of these statutes where Human Services Board is mentioned, but we just need to be aware of the fact that it serves as sort of the, before you go to court, it's the last level of appeal in the Agency of Human Services for many, many of the services that are provided at AHS or via AHS. So it's important. Thank you for sort of like giving us a visual of that. Yeah, go ahead.
Two questions. The first relates to, did I understand correctly that the board decision must ultimately be approved by the secretary
In some cases.
in some cases?
Yeah.
Okay. And then, and the part, Madam Chair, were you asking a question about, if I may understand this correctly, that the board's decisions must follow, if the agency followed applicable Vermont law, the board or the hearing officer need to follow that. And the question was raised about rules. There's the possibilities for the rules to conflict with statutory intent, as we've seen this term with Elcar's decision.
Mhm.
Where would that leave board or a hearing officer when they've got a conflict in rules? In that way?
Well, in theory, probably most of the rules have gone through Elcar, and if not approved, had no decision on them. And then if there was a conflict in state statute and the rules, the statute would take precedent over the rules when applying them.
So let's kind of play out that example a little bit, Doug. So in this case with the GA rules that, gone through Elcar and Elcar, ultimately determining that it didn't meet legislative intent in a couple of cases. If in the meantime, somebody had appealed based upon the rules that DCF had put in place, would they then have basis for reappeal, or would that decision have been final?
I don't know how that would play out if you're sort of in this limbo period is sort of what you're describing.
Yeah, so there's a decision that's been issued based upon the rules that are in effect,
Right.
and then the rules are ultimately determined to not be consistent with legislative intent of the law.
As that moves up the process, if it ended up with the Supreme Court, because Elcar objected, it would shift the burden to the state having to sort of make the showing that they were acting in conformity. So that's a higher burden for the state. I'm struggling because ultimately they were approved. So I would say,
Yeah,
if, at the point that they're approved, if they're still found to be by the hearing officer or the board, whoever is sort of looking at the facts and applying the law, if there's a conflict between rule and statute, it's going to be statute that has to be applied.
it's interesting because, they could find themselves in a little bit of a limbo case where there's still pending decision, like those rules went on for months. Like there's a pending decision.
Mhm.
They ultimately took out the references that Elcar found objectionable, and then they approved the rules.
Yeah, and then, sorry, in that case, it's even more complicated because the permanent rules hadn't taken effect yet. So really the emergency rules were still in effect in that situation.
Right.
And I think Elcar chose not to weigh in one way or the other.
On the
So
emergency
that-
rules.
Yeah, on the emergency
yeah.
rules. So that makes it even more complicated.
Yeah, I get the note here is you don't want to be a human services board hearing officer. That's what I'm saying
Well
about
said.
that, right? Okay, anybody else have any other questions about this? So think about this, think about what it might be like for an individual trying to appeal and to have their case heard. And we'll have some more discussion shortly, actually, to make a decision about whether we're going to take it off or they're going to officially take it off the board, as we say. So, all right, now we're going to shift gears. We're going to shift gears to H218, which is the opioid abatement settlement fund bill. And we have an amendment from the Appropriations Committee to consider. And since you're sitting in the chair already, Katie, I'm just gonna ask you to review the amendment.
Okay.
And then we'll have Representative Bloomley talk to us a little bit about why the Appropriations Committee made the amendment.
Sure. Okay. So here is the amendment, and this is the version that still has the highlighting of the changes that were made, hoping that that would make it easier to see the changes. So if you remember your section 1 of the opioid abatement special fund, bill, you had a whole list of items that were being appropriated from the special fund this coming fiscal year 26. And as you discussed the overdose prevention center, there was a conversation about how not all of last year's appropriation has been used. So you pulled that appropriation out of the list and instead had intent language that if it is determined that the 1.1 million is needed this year, or not the 1.1 million, but if some amount of the appropriation that they would have received is needed this year, they could request up to half during the budget adjustment process. And this committee, Appropriations Committee, would consider that request. So we sort of undone that move. So the result of which is adding the appropriation back in for the full 1.1 million. So that's added here at subdivision 5, 1.1 million to the Department of Health for the Overdose Prevention Center. And this language is identical to the language you had looked at in earlier drafts that had this language in the list. And then you can see that I've renumbered everything in the list, including subsection B, because B had been C, and B is the paragraph that we struck out. So you have a new section A to replace your old section A1 to make these changes.
So I have a question, like, why is it a strike all?
I know, I probably could have done it both ways. I was thinking that I would have to say twice that we have to renumber within the list in A, and then we have to renumber the section itself. And I thought that might become confusing, so I just decided to show it. But yes, it could have been done that way also.
Well, I did search to make sure that there was nothing else changed. Teresa, go to word by word. Okay. Okay, anybody have any? Yeah. Any other questions for Katie about sort of the construct of the amendment? Okay, and Nolan's here too, in case you have any questions about the fund. Actually, Nolan, it might be a good idea just for you to confirm for the committee that there's sufficient funds in the opioid settlement abatement fund to enable this appropriation, which I'm sure that the committee downstairs looked at, but just for our purposes, could you confirm that?
For the record, Nolan Langle from Joint Fiscal Office, yes.
And can you tell us what is the balance in that fund after if this appropriation passes, what would be the balance?
So for the shortest testimony ever. So after this, let me see if I can find the previously. Okay, so prior to this, as your bill had passed, you had $3.25 million on the bottom line. After this, you'll have 2.16 million on the bottom line. If I may, Madam Chair, some new information came to light after the bill had passed both chambers. Nothing that would change your decisions this year, but it's for further consideration. I did get some information from the Attorney General's office about how much money we anticipate to be coming in the future, or how much allocated to the fund, because they get the settlement fund, AG takes their piece. In 2025, and by the way, this does not include the Sackler-Purdue settlement. We don't know what that will be yet. So this is all the
most recent one, yeah.
Yeah, and that we'll know by the fall how much that will be. And we'll find out if that's going to be one time or if it's, so as you know, a lot of these, there's multiple parties who pay into this. Some of them have front loaded it. I'd be like Walmart, I think, paid it all up front, or some of them like Jensen pay multiple up front and some just do it over time. So there's more of a front loaded. So we know we've received over $26 million to date over the last 4 or 5 years. Going forward in 25, we're expecting 4.1 million. In 26, it'll be 4.4. In 27, it'll be 4.1. In 28, it'll be 4.8. And so you can see, and it's going to be in the 4 millions until you hit 2033, in which case it'll be about 2.9. And in 2034, it'll be 1.1. In 2035, it'll be 1.1. 2036, it becomes 626. 2037, 626, and then there's nothing past that. So it's front loaded. It'll start to dwindle over the years. Again, not taking into consideration the Sackler stuff, but I wanted this committee to know this information because I literally received it like 5 minutes after these guys voted out. So I did include it in my fiscal note, this little chart with that going forward so that folks have that information.
Thank you very much. And did you send us the updated fiscal note?
I can.
Okay, that would be great, so that Lori can post it up, that would be wonderful. Okay, Representative Bloomley. What retail was the appropriations committee up to? That's a loaded question, isn't it?
Nobody.
Yeah.
And I apologize for that, but
It's all good.
we had what we had. And we were able to pass the budget out unanimously. This is the first time since I've been on the appropriations committee, which is a good thing. So for the record, Tiff Bloomley from House Appropriations. I had actually asked Joint Fiscal to come up with, to show, because I've been concerned about the rate at which money was going out. It seems to take forever it has seemed to take forever to get some of these grants out. And Chair Wood and I actually spoke with folks at the Department of Health a couple summers ago about this. At any rate, I wanted to see an update on, well, what have we spent? And at first, I had kind of the same impulse that this committee had in terms of just rolling this year's money for the opioid overdose prevention center into FY26, and then, looking at things through the BAA. We know that the BAA does not necessarily ensure appropriations in any kind of timely way. And the Opioid Settlement Advisory Committee and this committee made a commitment to the Overdose Prevention Center, a multi-year commitment. And I have had numerous conversations with my mayor and with other city council members, et cetera, and the woman who's kind of spearheading this effort and got the budgets, the operating budgets. And there's a lot of work that goes into just setting it up. And there's a lot of community outreach that needs to be done in order to successfully site the location. And you've got to fit up a new facility, et cetera, et cetera. So it did not seem wise to me to hold back some of the money. We didn't do that for any of the other line items that hadn't been spent down. And so it just seemed kind of consistent with the wishes of the Opioid Settlement Advisory Committee to go ahead with the appropriation. And I think that everybody's learning more about they're building a system. We knew it would take time. I, to be honest, am quite frustrated by the fact that I hear from advocates or providers that they have billed down against their FY25 grant, but it's not reflected in the accounting that we're getting from the Department of Health. I don't know how to, I can't solve that problem right now, but it did seem to us on the committee that we ought to appropriate the full 1.1 million for FY26.
Thank you. I think the point that you make about there were other appropriations for 25 that have not been fully drawn down or even any drawn down yet, or at least
Apparently.
according to the Department of Health, that, that this was treated differently, I think I think that's a good observation. And as sometimes happens with bills, there's also additional information that becomes known after a bill passes out of our committee. And the city of Burlington has selected a provider, which was not known at the time that we passed the bill out of our committee. So they it will be in conversations with the mayor. This will be very shortly on the city council's agenda to approve. So things are moving along now, and as Rep. Quinley said, there's a lot of planning that goes into the establishment of a new program such as this. And being consistent also with the recommendations of the advisory council and the department put forth this as well. This seems to me to be a prudent amendment to our bill.
A friendly amendment, perhaps?
Yeah. It's always friendly. Yeah, if there are questions, go ahead, Ann.
So I understand, I don't have our original language next to us, but I understand, not using BAA as a, relied upon source for something. It does seem to me, I mean, there are certainly other places in state government where we take money back or roll it back when it's not used. So maybe not in the opioid fund, but that there's certainly lots of precedents for that. And it seems to me that given our commitment, we should be appropriating the originally intended amount, but not in excess of the per year amount intended. And so appropriating it, but also with language saying, except to the extent that they didn't use the current year's money, that they didn't fully expend it, they automatically get the additional to make it a full 1.1 million next year, but including using whatever's left over from the first year. Am I making sense?
Well, yes, I understand what you're
Yeah.
saying. So if there's unspent funds in 2025, then yes, they would get 1.1. Some of that might be made up of, just say 400,000 from
Right.
carryover and then, 700,000 in new funds. I think that that would be taken care of in the grant language that goes to the city. I mean, they're not going to just automatically get a grant for $1.1 million and
Go against.
that. I mean, they
Well,
will have to,
Yeah,
they will have to, quote unquote, draw down that money according to the grant agreement.
yeah. But I think under this language, they submit the grant proposal, and if they say, well, this is how much more we need more than 1.1 in this second year. That's not a part of commitment that, I think there was, I think it's reasonable to have an expectation that the city also contribute. And if the purpose is keeping to our original commitment, which is the basis on which I supported it, then just allowing for something that allows whatever the Department of Health responds to a grant proposal that might significantly exceed the 1.1 for next year.
Thank you.
I don't think it's appropriate. I will
I'm not,
support that.
I'm not understanding what you're suggesting though. So what are you suggesting?
I'm suggesting up to 1.1 million. I don't know the exact wording, up to 1.1 million next year, so the money's reserved. But that the actual grant would be limited to meeting 1.1 million with the inclusion of leftover funds from 2025. So that would be
So if there was unspent 400,000 in this current fiscal year, you're saying you don't want to see a request for 1.5 million in fiscal year 26?
exactly.
Almost all of the grants are underspent right now
Mhm.
because of the time it's taken. So that would have to apply then to all of the grants, I would think. I mean,
It happens to be it happens to be for those, and we don't even know how much is or isn't, or whether there's leftover.
Well, we-
And we have a lot of other precedents where we do it the way I'm describing. So the fact that this particular set of grants, which are all, well, a lot of the sub-grants are for much smaller amounts. I mean, that's what I think would be consistent with what, because this was set by the legislature last year. And so,
So I'm gonna ask a question of Katie. Yes,
Would you like me to?
no, we can, yeah. We, I'm understanding what you're saying, Anne. I'm also understanding the intent behind this. And that if there were to be language, it shouldn't only apply to this, frankly. But then I think it will, so I'm going to ask a question. In the lead-in language, Katie, so in fiscal year 2026, the following sum shall be appropriated. So I'm sure that there's problems with this, and so tell me what they are. If it said in fiscal year 2026, up to the following sum shall be appropriated. Because honestly, there could be carry forward from others.
that would make sense.
Um,
There will be.
There will be, right. And I'm just wondering if that gives an unintended consequence of giving the health department the ability to say, well, we don't really want to appropriate, 40,000 to Brattleboro's fire department or whatever it is, and we're only going to give them 35,000. It would give them that flexibility, wouldn't it? Yeah. That's the only part. Is there language that we could, is there language that we could further amend the bill to try to get at what Ann is talking about? Yeah.
Are you wanting like reversion language that applies, like any unspent money shall automatically come back to the
I
fund?
shall revert to the fund.
Oh, that would do it, because then they would get the full new appropriation, all of
That's what
them,
happens, but
as
yeah.
in the
Yeah.
statute. That, right.
I feel like I would want to work with JFO to get that right.
Do we know whether the grants permit them to draw money down? I mean, do they have carry forward provisions such as, we do as the,
Well, I feel honestly like we need to ask the health department that, what is the language in their grants? Because it is concerning, frankly, I'm just gonna say it on the record, that we cannot get really what I feel like is a straight answer, I heard from the same providers that Representative Lumley did, that they actually have received money that does not show up on the spreadsheet that the health department provided to us, or to JFO. And that's troubling. I don't know if that means that their accounting system is not up to date, or if that, I don't really understand the discrepancy between that. And it doesn't seem to have an answer that we can get. And I don't know if all of the grants would have the same, have some sort of standard language.
I
Yeah,
was wondering, there are 4 of these grants where we've made multi-year commitments.
Yes.
This is one of
This
those.
is one
So
of those,
those 4 might think of themselves as being somehow different than the remainder of the grants.
Yeah.
In this way that you're talking about.
right, right.
That because we made this commitment, then there's this automatic carryover they should expect.
Yeah,
And is that what we're trying to get at? Yeah.
For,
But maybe not all of the grants.
yeah. Well, we are going to, because Rep. McGuire is not here today, we are going to have this continued. So I think that we can actually get the health department to answer a couple of questions for us. But Rep. Lumley, you were going to say something.
I'm concerned about the word revert because the health department has entered into contracts at different points in a year, so that don't correspond with our fiscal year. So we would always want that money to carry forward because the year of the contract could be from May until, April. So I don't know what the appropriate legal construct is, but I know that a lot of the organizations that are funded through this are, that they need to be able to bill on a regular basis and know that the money is there that has been committed to the projects.
Yeah, so I agree. Just a second. Go ahead, Nolan.
So there's two ways that this shows up in there. There is unspent obligations. So they have a contract, they just haven't spent it all. And then there's amounts completely unobligated.
Yeah,
So I think you want to focus on the unobligated.
right. We did that.
So.
Yeah, because we reappropriated 300,000 of that or something like that. There's something down there that the mobile syringe site wasn't able, there was no response to the RFPs.
I guess I would ask the question. If there were some unspent funds from 2025 and this particular project really picks up speed, moves ahead faster than it has historically, and they have a need for greater than the 1.1, but within the total that we've
2.2.
of 2.2, where is the problem if it's executing on our goals?
That's why I don't personally see a problem with that, but I think that we need to understand what the grant agreement says about that. So
Which doesn't exist yet.
that's what I was just gonna say. So for this particular thing, but I think in the effort to try to treat all of these, I think Zon makes a good point, these recurring projects, these recurring obligations in the same manner, because some of them, according to records, haven't drawn down their funds yet either. And what Tiff says as well. So the grant agreement for the city of Burlington is not going to have a retroactive July 1 date on it. It will have a date of
October 1.
something. Well, no, hopefully sometime in this fiscal year. So it would honestly be probably inconceivable that they would draw down that whole 1.1 in this fiscal year. I would find that very hard to believe unless they made some major purchase of a building or something.
No, but it is expected that they will need the full 2 point.
That's what I mean.
Next,
Yeah, that's what I'm trying to get at in terms of what the department's language might be in that regard. Because what you were saying is a little bit different. You were saying, well, total would be up to 1.1. I think that the intent is that if they do require over these 2 fiscal years, 2.2, that they would have access to 2.2. Yeah.
So 2 parts of what I wanted to say before is, the concept is if there's the language from the legislature is, well, for instance, the 26 outreach positions. If they, because of workforce issues, they could only hire 20. I don't think we'd be expecting, if we repeat the language to say, the way we want to have it ongoing, that next year they could hire 32 because they'd have the leftover money. And that's I agree that it would make sense to apply the same to everything. But I think before delving into all of the work that would be needed to try to pin that down, if there's already, I have no sense of I do have maybe it's a little bit of a sense, but if the straw poll of the committee is you want them to have 2.2 million over 2 years, then there's no point in doing that work. I'm willing to be a losing vote rather than have the work done to have the same outcome, regardless of what information comes back about the doability.
I think, yes, I think the rub here is that there's been a commitment made to the idea of ongoing funding. And so we're wondering, so then do we sort of backtrack on that now? It's in a certain ways it's not backtracking entirely, but you're trying to control the spending, which I totally understand is reasonable. but we did make a commitment to ongoing funding.
Well, but the commitment was to 1.1 per year with the expectation that they were going to get up and rolling sooner, and they haven't. But I think we all understand the
Yeah.
viewpoints and.
Yeah. Yeah, go ahead, Doug.
I think though we may end up just bumping out we have currently funds through fiscal year 2028. We don't want them to be delayed in doing it because we need to bump it out to 2029. I think we've made a general commitment about the amount of funds we're willing to commit to this project and not as concerned about the timeline and how they've spent it, I guess.
Yeah, I do think that, I don't think any of us expected, a July 1 start date. The department wasn't even required to get the guidelines out until September, which they did on time, actually a little bit early. And so I think that, realistically, there really wouldn't have been an ability to spend the full 1.1 in initial year, but it will take 2.2. So I appreciate that, Anne. Why don't we, do people feel like they want to hear from the health department? Or are people ready to vote on the amendment?
I'm ready to vote.
Okay, all right, so this is a straw poll. Let's take a straw poll of those individuals in favor of the amendment that is being proposed by the Committee on Appropriations. Who is in favor of the amendment? So we have 1, 2, 3, 4, 5, 6, 7. Okay, who is opposed to the amendment? Okay, 7, 3, 1.
Since it's. Well, it is, since it's a straw poll, a person doesn't need to be here, and it seemed like the person who submitted a bill to withdraw all of the funding should be counted as a. I'm joking.
Well, actually, I can ask him. I mean, it's a straw poll.
It's a straw poll, so you
It's a
could
straw
ask him
poll.
afterwards.
He'll be here tomorrow.
Okay.
Yeah, he'll be here tomorrow.
Fair enough.
Okay, thank you, everybody. Thank you.
Thank you. Okay.
Everybody. Okay, all right. Jubilee, you're in the hot seat now. Thank you.
I have bills. I'll start with H 151, which is the restaurant meals program. Talked about it a little bit during the budget. And what it does is there is within USDA, within their SNAP program guidelines, it's kind of like a waiver. It's a little thing we could opt into as a state that would allow folks, just a narrow scope of the population, folks older Vermonters, 60 years and older, folks with disabilities and people experiencing homelessness to use their SNAP dollars, their 3 Squares benefits at participating restaurants, if we chose to opt into it. The restaurants would have to, in this bill, the restaurants would have to opt in and decide they want to be part of this. And it's kind of a move. We kind of did this on our own during the pandemic. And it helped keep a lot of restaurants in business. It's not only helps this population, but it also helps restaurants, especially in an economy where we depend a lot, in particular in some areas more than others, on tourists. And I know I've heard from local restaurants, they're very concerned with the perceived loss of tourists coming into Vermont from Canada. So I think this could really come at a great time for a lot of Vermonters. Didn't have a lot of time to prepare. I've been working on my floor speech. So I'm just going to read something I read during a press conference, give you guys a little idea about it. So right now, across Vermont, too many of our neighbors, older adults, individuals with disabilities, and those experiencing homelessness are facing a struggle on how to eat every day. Do they buy food or pay for medication? Do they go hungry or settle for whatever they can find, regardless of whether it meets their nutritional needs? Hunger is not just about lacking food, it's about lacking options. It's about lacking the means to prepare food, to store it, to make it last. It's about navigating a world that assumes everyone has a kitchen, a stove, and the ability to stand and cook. That assumption is wrong. Our current system tells people, here are your SNAP benefits, now go buy groceries and cook your meals. But what happens when you don't have a kitchen? What happens when you're living in your car? Or in a motel without a stove, or moving between shelters with nowhere to store food? What happens when your disability, your mobility, or your health makes cooking an impossible task? For too many Vermonters, the answer is tragic. They go without. That's why I was proud to introduce this bill that will direct Vermont to enroll in the USDA's Restaurant Meals Program, in conjunction with a bill that was also introduced in the Senate. This program already exists within the federal SNAP system. It allows states to give qualifying individuals the ability to use their benefits at participating restaurants. It's a simple but powerful tool that would allow older Vermont's, disabled individuals, and those without access to housing to have hot, prepared meals, food that they can eat right away, and food that doesn't require a kitchen and that meets their needs. This program is not a handout for a lot of folks, it's a lifeline. For our unhoused neighbor, it means finally having a way to use their benefits instead of watching them go unspent because they lack a kitchen. And this is more than just about food, it's about dignity. It's about recognizing that everyone deserves simple comfort of sitting down to a warm meal, whether it's in their own kitchen or their local diner. For an older Vermonter living alone, struggling with arthritis or limited mobility, it means getting a real meal without risking injury or exhaustion in the kitchen. For a disabled person who simply cannot stand long enough to cook, it means not having to rely on packaged, cold, or nutritionally inadequate food. And beyond meeting these critical needs, this program also strengthens our communities. It keeps federal dollars here in Vermont, supporting our local restaurants and small businesses. And it provides a social opportunity for older adults who are often isolated and struggling with loneliness. It ensures that our most vulnerable neighbors are not left behind. This is the kind of policy that makes sense. It's morally, economically, and logistically. This is about respect, dignity, and basic human decency. Vermont has always been a leader in fighting hunger, and we should not stop now. I encourage you all to stand behind this effort, and let's not wait until another winter passes with people going hungry in our streets or shelters and even in their own homes. Let's make sure that no one in our state, no matter what their circumstances, is denied something as basic and essential as a hot meal.
Believe, thanks. Thank you. Questions. So we did talk about this somewhat in the during our budget discussions and recommendations, and I'm just wondering to what extent I know it has the addition of a position and money for equipment, et cetera.
The one-time funds kind of help with that transition. I know in talking with other states who have implemented this program, they found, putting some of that one-time funds to really help launch the program, and then having that position to act as technical assistance and really be there to see things through, have made for a much stronger rollout with a lot of uptake. And it worked and run more smoothly by doing that.
How many other states do this? Do you know?
So it's in the double digits, 11, 8 or 9. Okay, but I know there's others that are considering it right now, kind of where we are. So
Yeah. And it's just at this point in time, trying to have something that has money and position
Yeah.
attached to it is a tough sell. If there was a way to be able to do this without having a position, maybe the one-time money we could get, for equipment kind of things, but I think it's gonna be difficult to get a position to do something like this, even though it's interesting because I had a very conservative member from the Northeast Kingdom ask me why we weren't doing this last year.
Yeah.
And because she had constituents who, in the situation you were talking about, they had disabilities, they were not able to stand and cook meals, yet they would have been able to utilize this benefit. So this is really about hungering the ability to utilize all the tools that are available to us. And as you said, this is a existing federal option that we're just not taking advantage of at this point in time. And, if there was any way to figure out how to do this without a position,
Yeah.
I think it would be a kind of a slam dunk kind of situation.
Yeah, so I think it's worth a conversation. There may be.
9 states do it.
Yeah.
Yeah, go ahead, Brenda.
I was wondering, how come, because this popped in my head over the hot meal. Is there any way you could make the snack card so they could use it for the hot food at like Hannaford's, Price Chopper, the hot rotisserie chicken, so that they still could get a hot meal without the
At a grocery
restaurant,
store,
at a grocery store?
I don't know if this
Is that anything anybody's checked into? Because
That's how
there's some
some,
wonderful hot meals.
yeah, there's some, there's also some people live in food deserts where there is, the closest grocery store is 30 minutes away. And, so that's not always accessible, but that is, in some of the states that do it, that's,
I'm
that would
wondering
be
if
an
that's an
option.
option that could be implemented without additional staff.
Yeah, we know they're set up to take the cards already.
Yeah, I mean, in those places that, we do have places where it's difficult to get to a grocery store, but it's unlikely that those places have restaurants either that are going to produce it. Yeah, Doug was first and then Esme.
So I struggle with the question I ask because I recognize the various circumstances people can be in, that they don't have a kitchen, they have limited mobility, et cetera. But I think we also know that food from restaurants is much more expensive. So I have a concern about the rate at which someone may be spending their SNAP benefits. And I know you pointed to instances where people maybe can't even spend all of their benefits if they have issues, but I fear the other end of the spectrum of people coming up short sooner in the month than they already do, utilizing the program.
Yeah, and this is more, it gives folks options. I think, I was talking with someone who had just spent, 8 solid days of rain, storms, living in their tent, and living on crackers and things like that. And we're just, the one thing that would really keep me going right now is if I could just go and get a hot bowl of soup. So it wouldn't be an everyday thing, or if you're having, let's say your disability is you have an autoimmune disorder where some days you're doing really great and then other days your body just cannot. And so it gives you that option on those hard days to be able to go and use your benefits. I think it's about choice and autonomy, and I think trusting people to make the best decisions for themselves on what they need. And this gives them that opportunity to make those choices.
Esme was next and then you.
Yeah, echoing that too, just, the operating within a really tight budget is definitely something that these folks are really used to. And, acknowledging the fact that a restaurant meal might cost more than that is just like, obviously second nature. That's not, okay, but let's see, my question was, oh, now I lost it. Oh, it was with the point about Hannaford's, which is, it's great that they offer that, but I think a huge aspect of this program is the economic benefit for Vermont businesses, and Hannaford doesn't need our money. No offense to Hannaford.
A lot of.
And I'm not, and of course, feeding people is number one. But if part of the impetus for this particular bill, this particular program is, in addition to having more choice, and for folks who cannot prepare hot meals, and it's the economic, like, I mean, during the pandemic, this was like palpable. Like the restaurants were like so appreciative for having this. Like I saw it like day in and day out. So I think it really does have like a ripple effect, and the money we put into this, even like for a one-time position, I think really would, the amount it would ripple into our economy would be really, really profound.
Thanks. Go ahead, Brenda, and then Anne.
And I was gonna say, it wouldn't be about the business to me, it'd be about the people. If they could get a hot chicken at Hannaford's, I wouldn't care less if Hannaford's is making money, if somebody could get a cup of soup, hot chicken, a sandwich all pre-made.
Luckily,
It's
that's,
all about the people.
Yeah.
If we could do it without it costing anybody any money, taxpayer money.
Yeah, well, I think that the other option though is other small local stores also accept EBT cards, and, you know, so it doesn't have to be.
sure, oh, like,
Doesn't have to be.
oh, I know.
You know,
For sure.
big thing, yeah. Anne.
So I assume we're in discussion, not
Yeah.
questioning. Okay, yeah. So, you know, I do start out with the concern about, it's not just a little bit more to eat in restaurants. It's a whole lot more. It's not something I can afford to do, except maybe once every 2 or 3 months. I live on buy one, get one free, whatever's on the, whatever's on that week. And so that's a huge concern, that people's ability to get food will be significantly reduced if they, you know, choose an option to eat out even just a couple times a month. I get it for people who are it's particularly challenging to be able to get hot food for any number of reasons, because you can always get a rotisserie chicken that's gotten cold, you know. But I think that's a very small percentage. If there were a way that it could be a targeted program for people in that category, that would make sense to me. But it's not it's not a large percentage. So there's a waiting there, and I think it is important to have choice and dignity, and allow people to make their choices. They make their choices about the kind of food they get, which we might not always agree are the healthiest or the best choices. They have those choices. But there is a flip side to that in terms of the extent to which you do that and the responsibility to taxpayers who are paying for it. And whether it's our federal taxes or our state taxes, we're paying for it. And I think knowing that for many, many people, they run out of their SNAP benefits as it is before the end of the month. And so the thought of people, running out sooner and ending up on average as a whole with less access to food than without this program, I really believe. And we all have our little experiences that you can't take in isolation but I know that to be true. And I don't blame people for wanting to have something a little special from time to time, even if that means, using my benefits up front the first week and then not having it later. Obviously, we all want more of that. But that flip side is this is expenditures that as a society we're making to help people get food and not face hunger as much. And I think we are disrupting that priority if we're expanding for restaurant use.
Can I just chime in? I see your hand. And there's a lot of what's very cool about this is when you do your application for this to have, to be able to offer this option. There are a lot of different models. I know some states, it's like, there's a special menu. So it's like, there's at the restaurant. So there, which anybody has to be able to access, but maybe it's like the $5 grilled cheese, $5. So that, so we have ways to limit and guide that. Some states not go this route, they've partnered with a fast food restaurant. So it's like the dollar menu items, which concerns me a bit. So there are a lot of ways you can navigate that and address those concerns and work with restaurants.
Todd, and then back to Ann. So,
Esme.
sorry, I didn't.
Yeah, Esme.
She was first.
Oh, okay, I'm sorry.
I mean, I really appreciate the comment because yes, we want people fed, absolutely. And, but at the same time, we don't want to like spoon feed someone who's in poverty, like what we're allowed to, we feel is the right thing to feed them because it's cheaper, or it's like you could get more bang for your buck, like it feels like really weird and icky to me. And, just like, I think many of us here budget, and of course, everyone comes from different circumstances, but why is it, I don't know, it just doesn't feel fair to me to say, oh, well, I coupon, like I get, I have to buy from the cheap option. I only can go out to a restaurant like once a week. Why cannot they have the same decision? They know they have a budget just as anyone else does, so like, why are we being like, oh, but they shouldn't be able to budget, like, because they don't know what's best for their body.
Yeah.
Like, it's just, I see that it's like maybe you, from an outside perspective, state administered program, oh, we don't think it's the best bang for your buck because it's more expensive. But I feel like that is if you qualify for the benefit, you should know, you can know what's best for your body in that certain situation. So I really struggle with that argument about budgeting, and like, hopefully that makes sense.
Well, it's presuming competence for it.
Exactly.
It's like what we deal with folks with disabilities all the time is I always try to say presume competence
Yes.
versus don't presume incompetence, so, we've got Todd and we've got Ann, and then we got Dan.
Me and my wife, we don't go out often, but we do go out and eat. We have a hard time finding lunch vouchers for $45, not including tip. Usually like around $75 for lunch. We usually don't go out for dinner because we like the lunch menu.
Mhm.
But $45, the money be gone pretty quick. And that's my opinion.
I think that's what Ann was saying too. Yeah, go ahead.
Yeah,
Ann. And then we're gonna
quick
move on to,
response.
after
Yeah,
Dan, we're gonna move on
yeah,
to the
yeah.
next bill.
We're talking about what's the best bang for our buck as taxpayers, and what do we want to benefit people with? More food or more ability to choose specialized food? And I think a big piece that we need to keep in mind is public perception, and how a negative public perception can hurt the people we're trying to help in the long run. And, I have no problem defending and talking to people. You hear that, well, these people reach up, I see them, they look perfectly able-bodied, don't know why they can't get jobs. And, you can talk people through that and get them to understand. Or I saw so-and-so gets all this, junk food at the store. But if you get to the level of they can use food stamps to go to a restaurant, that's really hard to defend publicly. And that affects how people make their own decisions about what we should or shouldn't do to help people who need a helping hand. And I think it can create a lot of harm.
Thanks, Ann. Dan?
If we were to take this bill up, it'd be great to see if we could include congregate meals at senior centers as a way have the technology for them to be able to take the money.
Yeah, Dan and I talked about that quite a bit last year. And I just also do want to say that the kinds of meals that folks within this group are now having to eat are things that are prepackaged, full of sodium, full of chemicals, are things that have to be reheated. And so this also allows them more opportunities to have nutritious food and to meet. I talked a lot about meeting their needs. One of the things we've heard a lot about and why some of the other programs only go to 65 up, and this includes 60 and up, and people with disabilities who often have nutritional needs that they are not able to meet through the food shelf and through the types of food they're otherwise able to keep on hand without this option. So there is some benefit to people's medical situations and not furthering medical conditions. My next bill, I'm sure this one's going to be very popular. This is a short form bill, really just starting a conversation. I
Second, about this last
Yeah,
one?
yeah. I'm sorry, you just made reference to this is folks 60 and under and people with a disability?
and people experience older.
Older, okay. I didn't see that language anywhere in here. I just.
Yeah. That's who
Qualifies for the program.
under this kind of like waiver.
Under the federal.
Yeah,
Okay,
yeah.
thank you.
People 60 and older, people with disabilities, and people who are experiencing homelessness. Okay, so yes.
Do you mind if I just follow up on the one last piece on that bill? I'm so sorry, it'll be very brief, but I think
To apologize.
I think it intersects with a lot of our other bills here, especially in the Committee on Human Services, where we deal with a lot of vulnerable populations and populations that are often like, well, in some cases, villainized for like, the government providing services. And I think that goes into your point, Rep. Donahue, about narrative and like how narratives can be harmful. And I think that is absolutely really something important to talk about. But we have a lot of power here in this committee too, to not control, but to inform their narrative. So if we're not let's not choose to take a bill off the wall or not take a bill off the wall because we think, oh, the public perception is going to be like,
Yeah.
oh, these people are like totally grazing off this system. If we're like expecting that pushback, like, then let's inform like, well, is this bill actually supporting the initiative we want? We can provide data, we can provide facts. So maybe it's not with this specific bill example, but like, or it could be, but like we pass a bill because it's good policy, not because, and we can control that policy as well.
So. Yeah. Okay. Maybe.
Everything I said was just upended a minute ago, so I really.
You want to respond?
Okay.
Go ahead.
I said earlier that the vast majority wouldn't fit in this need category. And that if it were more restricted, I'd be more open to it. In all this discussion, I didn't hear till your last comment.
I did say it in there.
I missed it.
Yeah.
I missed it. So I missed that part. And so when I said that before, that's like I don't want to re-enter the whole discussion. But my comments were really based on assuming it was for anybody with SNAP benefits. And because I looked at the language and didn't see anything restricting it. So anyway, just.
Yeah. Thank you for that clarification, Ann.
You did say earlier, if it were narrower.
Right,
Yes,
and that,
yeah.
and that
And
it
that
would
actually
only be a
is
small
narrower.
percentage of.
I was like, how much further do we want to narrow it?
Yeah, right, but yeah, because it'd be a
That makes sense.
small percentage, and in fact, it would be a much larger percentage among that group than if it was everyone. Anyway,
Yeah, okay. It is so just so everybody understands that the federal opt-in program is for the categories that Jubilee described. So people over the age of 60, people with disabilities, and people who are homeless. It's not for the broad category of people who are otherwise eligible for SNAP. So, okay, let's move on.
So this next one, so I participated in the NCSL's National Council, state legislatures, youth homelessness cohort, and have participated since then in a lot of different things related to that. Just joining the youth homelessness education work group. This is a population that I work with and might work outside of the legislature. And so I go to lots of conferences and things like that, including a recent, the National Runaway and Homeless Youth Annual Conference. And so this is always a really big topic in those kinds of spaces. And so this is really just starting a conversation. So it's a short form bill, so it could really, gives us a lot of room to work with. And I introduced the bill to address the pressing and often overlooked issue of homelessness among transition age youth. This bill proposes the creation of a universal basic income program aimed specifically at homeless youth aged 18 to 24 in our state. It's a bill that speaks to the heart of equity, opportunity, and compassion. And it comes at a time when we have a unique opportunity to make a tangible difference in the lives of young Vermonters. The problem is youth in this age group are often caught in a difficult generational cycle without a stable home and often poor relationships from the people we would consider their natural supports. They are cut off from resources needed to thrive, including education and pathways to sustainable employment opportunities. And a lack of support from parents or guardians is also one of the most significant barriers they face. I just kind of want you to think about your own life, and when you're in that age group, even though you're an adult, I know I personally really depended on the adults in my life, whether it was monetary or giving advice or, to go and stay home for a weekend. I received a lot of support, despite being a youth experiencing homelessness at the time. And most of these youth don't even have that. Many of these young people have been rejected, neglected, or aged out of the foster care system. And without the emotional, financial, and social safety net that many of us take for granted, they are left to fend for themselves in a world that is already challenging for adults, let alone for those who are still finding their way. Many of these young people also face trauma, which compounds their challenges and creates additional barriers to stability. They often find themselves at a crossroads where they must decide between survival or long-term stability. Without intervention, we know they are also the group most likely to go on to experience chronic homelessness into their adult lives. This bill will provide them with the basic resources they need to build a future free of the constant anxiety of finding shelter and stability. We've seen time and time again that financial insecurity is one of the biggest barriers for all Vermonters, but this is especially true for homeless youth. When young people lack a consistent income, they are unable to access the tools they need to pursue education, healthcare, or job opportunities. Instead, they are stuck in the short-term cycle of survival that prevents them from planning for their future. This bill establishes UBI, a program meant to help these young people meet those basic needs, but more importantly, it will allow them to regain control of their futures, giving them the freedom to pursue education, find stable work, and invest in their personal development without constantly worrying about their day-to-day. There are legislative precedents and all sorts of data around this from other areas. This is not an untested idea. There are numerous examples from other regions where UBI programs have already been successful in supporting homeless and low-income individuals. In California, SEED, Stockton Economic Empowerment Demonstration, provided monthly income to 125 residents, and the results were transformative. Participants experienced improved mental health. They reduced their stress and increased in full-time employment, and they found housing and were stably housed. They resolved their homelessness. not all of the participants were homeless, but that's true for those. For many, the financial cushion allowed them to pursue new opportunities without crushing the weight of poverty. In the state of Alaska, a form of universal basic income has been in place for decades through the permanent fund dividend. Program provides yearly payments to all residents, and it has been shown to increase financial stability, reduce poverty, and improve overall well-being. While this one's not specifically targeted, the lessons from the program are clear that direct financial support helps individuals regain control over their circumstances. In Ontario, Canada, they have a UBI that's specifically targeted people homeless or at risk of homelessness. And there was a significant reduction in housing instability, and people were able to secure steady employment, continue their education. Rates of substance use went down, cigarette use, all of those things went down. Thanks to the financial stability the program offered. These examples, some of many, New York City has them, California has multiple, Colorado, Georgia, Illinois, Massachusetts, Maryland, Michigan, Minnesota, New Mexico, New York, Texas, and even right here in Vermont, Spectrum. My friend Mark Redmond was able to find a private donor who has funded a pilot project, and I'm sure he would be happy to come in and talk about what that data and what the initial results are here in Vermont. And I can tell you they're really, really good. So yes, we know that homeless youth often lack the resources and guidance that are critical for success. But with a reliable source of income, they can access those services and opportunities, help them break free from the cycle of homelessness and poverty. It not only provides immediate relief, but will also create the conditions for long-term success by allowing them to pursue a stable future. This bill also offers homeless youth the dignity of choice, rather than being subject to a system that often feels dehumanizing. They will have the financial support to decide for themselves how to best to invest in their futures, whether that's their education, their employment. It's giving them the tools they need to break out of the cycle of homelessness and poverty. So thank you.
Thanks, Jubilee. Do you know how many, you have any data about how many youth this would be?
I left it open to completely, I didn't want to, it was a short-term bill, and I was honoring our ledge council and the historic number of bill requests they were getting, and also knew it would be a bill that would be a strike most likely, and so I just kept it at that.
Yeah.
And that gives us the flexibility. I can talk about, the way states that have done this legislatively have started small. They've chosen
A pilot.
an area, and done that, started small, and then, chosen to go from there.
Okay, thank you. Alrighty, yeah, we're, I just want to, do you have Older Vermonters Caucus?
No,
No, okay.
But thank you.
Just want to make sure, okay.
So I think this is an area that is deserving of a whole lot more looking what we can and do. I actually have a bill that's like very tangentially. Yeah.
Not quite,
But the same focus. And of course, I started my whole career, 10 years working with runaway and homeless youth. So I just want to be just a tiny bit picky here.
Yeah.
You'll need to change it. The title will have to change because I believe that technically speaking, once you're 18, you cannot be a runaway youth.
Anyway. Yeah. No, you're correct.
That's it.
Okay,
That's fixable.
Yeah, we usually call them transition age youth.
yeah,
Because it's really, the data shows time and time again that they're the most, we can really change that course. I was so lucky. I was a homeless youth. I was in and out of homelessness during this age group. I was unsheltered, I was in shelter, and I was so incredibly lucky to have an apartment with services and a voucher and being connected with all of the right people at the right time. But I know without that intervention, I would not be here today. I would be someone in the hotels right now, probably wondering what I'm going to do, or I probably, wouldn't even be in the hotels. We know without intervention, this is the group of people who go on to be our chronically homeless adults. With intervention, they are so successful. I see amazing stories that I can't share because of, but really amazing stories. And really, I think this is a population that investing in now will really save our state in long-term costs.
And who would pay for this? The taxpayer, the whole middle class?
Come from our state
struggling?
bottle.
Okay, thank you. I just wanted that on camera.
The,
Well, just so I can point
I
out.
know,
Okay.
I'm not sure the on-camera comment is required.
Oh, well,
You can state your opinion and ask a question.
I'm sorry, but taxpayers need to know that because they're struggling.
It is on my webpage if folks would like to learn
This is
more about my stance on this.
Thank you. Dan.
Thank you so much. This population definitely has different outcomes in their lives if they're supported when they are transitioning to adulthood, for employment, for housing, substance use. And should we take this bill up, having Spectrum come in, and there was a young woman who participated in their pilot study it's just really great to hear the impact even a small amount of money had on being able to make that transition and to be employed and to have a vehicle and be able to succeed in life. So thanks. It's very, it is very true that this will make a difference.
I think what we've seen this morning in a number of our bills is the impact of poverty and trying to address the impacts of poverty and certain life transitions for people. And I think those are all things that, our committee is charged with trying to address in the ways that we can. So thank all of the bill sponsors this morning for presenting their bills. Appreciated the dialogue. I think it is helpful for us to listen to one another and to learn from each other's experiences and thoughts about things, because we all bring those experiences to the table here. So thank you. We will be on the floor at 1, and it feels like there was something else I was going to say, and what is it? H91, our shelter bill is probably going to get voted out of appropriations tomorrow. So it'll be on notice on Friday, and then we'll be presenting it on Tuesday next week. So that's where that stands. We're going to have a caucus of the whole today to talk about budget and learn about budget. So I encourage you to pay close attention and to be thinking about the things that were in our recommendations that made it to the final budget in the House, and then the things that didn't make it to the final. Because we have some things that I think that we can work on in the Senate that they frankly just ran out of time to do in the House, that don't require new general fund. That are language things that will make a difference, and things appropriated from, for instance, the prevention funds from cannabis excise tax that we had recommended go towards recovery centers and mentor. It's being one, and then we had some CHINS language for the domestic violence visitation program. And I think that we can affect those kinds of things as the process continues. So just wanted to let people know where things are at. I think that's it. I'm just trying to think if there are any updates I need to provide. I don't think so. It'll be a pretty long floor. We won't be back here after floor. So have a nice evening. Oh, I shouldn't say that.